All right, good afternoon. The court calls cause number T20-52, Canton ISD, Van Zandt County, City of Canton, et al. Versus New Beginnings Fellowship Church, Arise Church of Canton, Barney Joe Donaldson Jr. Mr. Brand, are you here on behalf of the plaintiffs?
I am.
Mr. Donaldson, can you see and hear the court okay?
Yes, Your Honor.
All right, Ms. Harbor, can you see and hear the court as well?
Yes, I can.
Okay. And is it my understanding that Ms. Harbor is she a necessary party to the suit?
She is.
Okay. All right, I don't have her listed on my docket. I'll write her down. All right, the court's called the case. I do not see on file with the record what the nature of today's hearing, who requested this hearing today?
I believe Mr. Donaldson did.
Mr. Donaldson, did you request today's hearing?
I asked to be heard on my plea for partition.
For the record, Richard Brand for the plaintiffs, Van Zandt County et al. We are ready to go forward with this for announcements.
Okay. And Mr. Donaldson, are you representing yourself today?
Yes, Your Honor.
And it's not your intention to have legal counsel represent you?
Not at this time.
Ms. Harbor, are you representing yourself today?
Yes, Your Honor, I am.
And it's not your intention to request counsel either?
No, sir.
Okay. And I'm getting some audio feedback. I don't know if either one of you are outside or have a fan or window open, but here, so.
Okay.
All right. And Mr. Donaldson, what is your announcement on your plea for partition?
Simply that, have you read, I'm sorry, that background noise is real loud in my ear. Have you read the brief in support of the plea for partition?
I don't know that I have.
I'll put it in summary. The property was purchased by New Beginnings Fellowship Church in 2017 with a $75,000 promissory note. In 2018, I paid.
Hang on, Mr. Donaldson. Mr. Brand, yes, sir.
Yeah, before we go forward, can we get both Mr. Donaldson and Ms. Harbor to make an appearance, just for the record?
Mr. Donaldson, are you making an appearance on behalf of yourself and New Beginnings Fellowship Church or Arise Church of Canton?
I make an appearance only on behalf of myself. New Beginnings Fellowship Church is not a legal entity anymore.
Okay, thank you, sir. Ms. Harbor, are you making an appearance on behalf of yourself or Arise Church or both? And I had to mute you because I think you had all the background noise. You have to unmute.
Both,
Both?
yes.
Your Honor, but I would ask at this time that the court take notice that both Mr. Donaldson and Ms. Harbor have subjected themselves to the jurisdiction of the court. We have had an issue trying to get Ms. Harbor personally served, but by appearing today, she has subjected herself to the jurisdiction of the court.
All right, the court will take notice that Ms. Harbor has made an announcement and appearance on behalf of herself today and submitted herself to the jurisdiction of the court. Sorry to interrupt you, Mr. Donaldson. And if you're asking if I've read the statement of facts contained in the original answer, I have done that. I think you're referencing a separate brief in support. I don't see any briefs in support, but I have read your answer containing your general denial and plea for partition and statement of facts.
There was a brief in support of plea for the partition filed a couple of weeks ago. It repeats basically the same thing, but it has all the evidence attached to it. 2017, the church bought the property. They paid all the taxes that were then due at the time. The title company paid it off. I have attached Exhibit E, the tax certificate on that. The church executed a $75,000 promissory note. They borrowed money. There was a mortgage on the property. In 2019, I used my inheritance funds to pay off that mortgage note. It was a conditional gift, conditioned on them giving me one room in the property as my own separate property, and that that I would be the senior minister over that facility until I could no longer perform the job myself. April 2019, a master deed was filed dividing the property into 55 separate rooms. That's instrument number 2019-2715. And attached to the brief Exhibit C is a written deed from the church dated, I believe, April 3rd, 2019, giving me one room within that property. This deed has been submitted to the Van Zant County Appraisal District, and they've taken the position that until the deed is recorded of record, it's not legal or valid. And I've attached, I've cited in the brief a Bell versus Smith. It's not necessary that a deed be recorded in order to effect a conveyance of title. Simply put, I'm asking Your Honor to sign a proposed order that I've submitted. Section 3346 of the tax code says if a suit is filed to foreclose a tax lien on a real property owned in undivided interest by two or more persons, one or more of the owners may have the property partitioned in the manner prescribed by law, and that the court shall apportion the taxes, penalties, and interest on each owner. And I'm just asking that's what I'm asking my plea for partition.
Thank you, Mr. Donaldson. Mr. Brand, would you like to respond?
Your Honor, we'll wait until our turn to put on it.
Okay.
I don't see any to do it.
Can't hear him, Your Honor.
And just make sure you speak into that microphone, Mr. Brand, and you don't have to stand up. I know you do that out of respect for the court, but I'm going to waive that. You don't have to do that so that you can stay close to the microphone.
Your Honor, we would waive opening if that is what it is, or what Scott's asking for. We'll wait for our arguments until after we put on evidence.
All right, Mr. Donaldson, do you want to go ahead and put on your evidence?
The evidence is simply the exhibits attached to the brief that I've submitted. That's simple a plea. I don't know what else I could submit.
Do you have any objections to Mr. Donaldson's exhibits that he's attached to his brief in support, which has been filed with the district clerk?
Yes, Your Honor, we do.
Okay, what are your objections?
I have not been served with a brief. I don't know what the exhibits are. However, I'm going to assume that I have most of the same exhibits prepared to introduce myself, but without knowing what it is he's introducing, I just cannot agree to it.
Mr. Donaldson, did you provide service to the taxing entities legal representation to counsel?
Yes, Your Honor. These were e-filed and e-served on the 5th of April.
And who did you e-file? What was the name or the address of the individual or entity that you e-served?
Give me a second here and I'll tell you, I'm pulling it up right now. Accepted. Actions, view envelope. They were served on the counsel Hannah Zweeb on 4/5/21, and it shows that she did actually open up a copy of the served document. Sorry, can you hear me?
Yes, we can hear you.
Sweden is not an attorney. And to my knowledge, has never presented herself as an attorney. She does work with my office. I would still raise the same objection. If he wants to individually offer evidence, at that point, I'd be happy to review it, but to waive objection, carte blanche will just be bad practice on my behalf.
Do you want to make an individual offer of evidence? Mr. Donaldson?
I'm just backing up on the pleading filed by the Linebarger. Hannah Zweeb is the only counsel listed on the e-file system as a party in this case. And it has an address at hannah.zweeb@LGBS. That's the only party that can be served. It's on the e-file system. So, all right, let me get back to where I was at here. All right, now, Your Honor, I apologize. I'm trying to figure this out. What are you asking me exactly? Do I want to present these today or what?
I believe what Mr. Brand is saying is that he's not familiar with your exhibits that you're wanting to offer. I believe he said that he may in fact have all of these same exhibits, but he can't just carte blanche stipulate to their admission without knowing what they are. So correct me if I'm
Okay.
wrong. It seems like Mr. Brand wants you to offer each one and describe what it is. And then I believe that'll put him in a position whether he could agree or he would object.
All right, let me get back to it.
Judge,
The
if
first-
it would make it easier, I do have a series of deeds that Mr. Donaldson, unless I'm mistaken, these are probably what you are attempting to introduce. I already have them marked. One is the deed from New Beginning Fellowship Church of Houston to Chapman House, filed on March 10th of 2021. Is that one that you are intending to introduce?
No, actually, that's not one of them.
All right, how about Chapman House to Arise Church of Canton, filed May 6th of 2020. Is that one that you're intending to file?
No, Your Honor. I'm saying, sorry, no, sir.
How about New Beginnings Fellowship Church of Houston to Chapman House, Eustis, filed March 16th of 2020. Is that one that you're intending to file?
No, Your Honor.
All right, then I'm gonna continue my objection that I don't know what he is attempting to introduce. I don't know what vehicle he's attempting to introduce it under either.
All right, let me do this to save the court's time. I'm going to print Mr. Donaldson's brief in support. That's going to have the, now I'm going to provide that to Mr. Brand so that you can look and see.
Thank you, Judge.
So give me just one moment. I'm going to give Mr. Brand just a moment to review your exhibits attached to your brief.
Okay.
There's such a habit to stand up. It's hard not to stand up.
I can get you a podium here if you want one. I mean,
Just when addressing the court, it's hard for me not to. I'm sorry. Exhibit D is,
well, just take a moment and review all of them. Tell me which ones you agree to and which ones you don't.
Your Honor, I would object to A, B, and C at the end. Sorry, pure habit. I would object to A, B, and C, being no foundation, improper to come in hearsay. As far as exhibit D goes, that is the correction deed without warranty for New Beginnings Fellowship Church to Chapman House, Eustis Incorporated, that was filed on March 10th, 2021. I actually have a certified copy here, which would be the correct way to introduce this, as it is a public record. It doesn't have to have a foundation. If Mr. Donaldson and Ms. Harbor are willing, I'll go ahead and go through the procedure of introducing that instrument for Mr. Donaldson and present it to the court as a certified copy. Are you all right with that, Mr. Donaldson?
I think so. I can't hear what you're saying, Your Honor.
I'm going to paraphrase here. I believe that Mr. Brand's saying that he has a certified copy of Exhibit D and he's willing to offer that.
Okay. Am I able to offer my own testimony to verify that these other documents are my personal records?
Well, I haven't ruled on A, B, and C.
Okay.
He's saying he's objected. I haven't ruled on that. He's
Okay.
saying that he's willing to stipulate to D, but he would like to offer the certified copy that he has. Am I
All
correct?
right.
Yes, Your Honor. With the one caveat on it is in preparing, I've already marked my exhibit as Exhibit J. That would be the only difference in it, and I would stipulate that defendant's Exhibit D in his brief is the plaintiff's Exhibit J. They are the same document, except the only difference on it being that my copy does have the seal and signature of being certified. Other than that, they're identical.
All right. If I can, let me view that. All right, the court has reviewed plaintiff's Exhibit J and defendant's Exhibit D. The court finds them to be the same, with the exception of the cover page is stamped official certified copy of Van Zandt County. So the court will admit plaintiff's Exhibit J, which is the same offer as defendant's Exhibit D. So your objection to A, B, and C were what again? Foundation, hearsay?
Your Honor, foundation, hearsay, and honestly relevance.
And would you like to respond to that, Mr. Donaldson?
I believe it's very much relevant. The Exhibit D is correcting earlier deeds and
Well, Exhibit D is already in evidence. This is only with regards to A, B, and C.
well, at this point, A is not relevant because that's concerning the total amount of taxes due. Exhibit B is relevant only to show that I paid out of my, it's a copy of a check showing that I paid $75,000 toward the property. Exhibit C is relevant simply, it's a warranty deed granting me the property, the one room within the property. And it's confirmed by the one you've already admitted, Exhibit D, that that room was corrected. So I'm sorry, that's the best I can explain it.
Okay. The court will sustain the objection as to foundation and relevance as to exhibits A, B, and C. The court has admitted plaintiff's J, which is defendant's D.
Okay.
Do you offer evidence at this time, Mr. Donaldson?
Yes, Your Honor.
Go ahead.
Exhibit D is a correction deed at page 3. Corrects an earlier deed. It says conveyance is made subject to a reservation and exception of conveyance as follows. This correction deed without warranty does not convey specific portions of the property. Although the original documents were lost or stolen, this correctional deed without warranty is filed of record to evidence that on April 1st, 2019, by written deeds, specific portions of the property were transferred as follows. Room 3, D3 to Roy Martinez, room D4 to John Incravati, room D5 to Richard Grega, room D6 to Cheryl Hunt, room D7 to Barney Donaldson, room D8 to Stephen Phillips, and room D10 to Stephen Wilson. And then it references the actual real property recording that divided the property. I'm simply asking the court to let me order them to assess the taxes separately on my room, to partition the property. That's all I'm asking.
Do you rest as to your evidence?
Yes, Your Honor.
Okay. And Ms. Harbor, do you have any evidence you want to offer at this time? And you'll have to unmute your device again.
No, sir, not at this time.
Okay. All right. Mr. Brand?
Your Honor, I'd like to ask Mr. Donaldson a few questions. Can you swear him in?
All right, Mr. Donaldson, if you'll raise your right hand.
I'm sorry.
Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may put your hand down. Go ahead, Mr. Brandon. Just make sure you speak up loudly and clearly into the microphone so Mr.
Yes,
Donaldson can hear you.
Mr. Donaldson, can you hear me all right?
Barely, but I can hear you.
All right, I'm gonna put this right next to me. Is that any better?
It sounds like you're in an echo chamber, but I think I can understand you good enough. I'm going to turn the volume up at my end.
And
All right.
if you need, sometimes it helps if you want to approach and stand here at the bench and bring your papers with you, that'll be fine.
I don't think that microphone at his table is on.
Well, I assure you it is.
Is this any better, Mr. Donaldson?
I can hear you loud and clear now.
All right. Before we begin, I would like to offer the court a series of certified copies of public record. As such, they do not need a foundation or a sponsored witness. First one is Plaintiff's Exhibit D, which is a certified copy of a permanent injunction and final judgment out of cause number 19-00185. I would also ask the court to take judicial notice of the court's record in cause number 19-00185.
Do you have any objection to that offer?
No, Your Honor. We're familiar with all of that.
Okay, then plaintiff's Exhibit D is admitted into evidence.
And judicial notice.
And the court will take judicial notice of filings in cause number 19-00185.
Next, we would offer plaintiff's Exhibit E, New Beginnings, which is a certified copy of a deed of between New Beginnings Fellowship Church of Houston, Texas, to Chapman's House, Eustis Incorporated, which was filed March 16th of 2020.
Any objection?
No, Your Honor.
All right, the court then admits plaintiff's Exhibit E.
We'd offer what has been previously marked as plaintiff's Exhibit F, which is a deed, a certified copy of the deed from Chapman House Eustis to Arise Church of Canton, which was filed on March 6th of 2020.
Any objection?
No, Your Honor.
All right, plaintiff's Exhibit F is admitted into evidence.
Mr. Donaldson, did you join the stipulated permanent injunction and final order in cause number 19-185?
No.
That's not your signature on the deed?
You just have as stipulated injunction. What are you talking about?
There was a lawsuit filed by the city of Canton against New Beginning Fellowship Church, Barnold Joe Donaldson Jr., Covenant Community of New Beginnings Fellowship, Chapman House, Dean Harbor, Jamie Lynn Harbor, New Beginnings Fellowship of Canton, Arise Church of Canton, Kevin Chapman, Donna Vega, the structure and the real property known at 901 West College Street.
Okay.
Are you aware of this permanent injunction that was
Yeah.
filed?
Yes, I am.
Mr. Donaldson, when did New Beginnings dissolve?
Believe it was November of last year. There has not been a formal filing. All it was a meeting agreed to dissolve. I think it was like right before Thanksgiving.
All right. Mr. Donald, in your answer, you stated in paragraph 7, 8, and 12 that New Beginnings never actually had legal ownership of the property. Are you continuing that argument?
It's debatable. If we want to go down that road, it's very debatable whether it was ever transferred to us. We ended up entering into a final settlement with the Chapman House, and they agreed to transfer it to the Arise Church, and that ended that controversy. But when the property was sold to New Beginnings Fellowship Church, it was sold by Kevin Chapman, not the Chapman House, and Kevin Chapman did not have title to the property to sell or transfer it.
So is the answer yes or no is what I'm looking for?
I don't believe that we had title to the property, but it was settled. So that's the best I can do. We settled the issue.
You settled the issue in cause number 19-00185, correct?
No, that was a out of court settlement with Mr. Raymond Shackelford and the title company on that issue.
And that is the mutual release, which was filed into that case, correct?
I don't know. I wasn't a party to that case at that time. They'd already non-suited me.
Judge, I would ask that you take judicial notice in the file of 19-185. That case, Exhibit C, which was admitted, does have Mr. Donaldson's signature and was included in the final order.
Exhibit C of 19-185.
That passed the witness.
No, I'm asking, you said Exhibit C. I don't have an Exhibit C
No,
today.
sir, it's included in Exhibit D for this case. It was previously admitted as Exhibit C in 19-185.
So you want me to take, but
Judicial notice.
it's already in plaintiff's deed.
Yes, sir. Yes, sir. Mr. Donaldson did sign on to that mutual release, which conveyed ownership to Arise. He agreed that that was proper.
And Mr. Donaldson, are you contending at this time that you did not? Is that right?
I don't know what document he's talking about. I believe it's the settlement that was done in that case with Raymond Shackelford, where the New Beginnings Fellowship Church released Chapman House from any liability. Okay, let me see. Chapman House, okay, I see what you're talking about, yes. All right, sir.
Okay. So the court will take judicial notice of Exhibit C included in Exhibit D.
Your Honor, read past the witness.
All right, Mr. Donaldson, do you have anything else you want to offer since you've been called as a witness at this time? Do you want to offer any kind of responses or rebuttal evidence to the direct testimony?
The document that he's referring to is a release from New Beginnings Fellowship Church of all claims against Chapman House for fraud. I'm trying to remember what else was involved in there. I believe it was fraud, misrepresentation, and a bunch of other stuff. That document did not release my ownership of my room in that property. All that did was release our claims and allow the church's interest, what would remain in the property, to transfer to Arise Church of Canton.
Okay. Any additional questions of Mr. Donaldson?
No further questions, Mr. Dodson.
Okay, any additional witnesses?
For me, are Mr. Dodson rest?
Well, I believe you called
I
him
would
as a
call-
witness.
I would call Scott Hyde.
All right, Mr. Hyde, if you'll come forward and have a seat in the witness stand.
Is it all right if I question him from here?
Yes, yes. Before you have a seat, let me go ahead and have you raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Please have a seat. Bailiff's going to adjust the microphone, ask that you just speak up loudly and clearly so that everyone can hear you, especially my court reporter here to your left, and make sure that you don't speak over Mr. Brand or Mr. Donaldson or Ms. Harbor, and they're going to extend the same courtesy to you.
Yes, sir.
All right, go ahead, Mr. Brand.
Would you state your name and spell your last name for the record?
Scott Hyde, Hyde.
How are you employed?
I'm employed by the Van Zandt County Appraisal District.
There.
I'm the chief appraiser and tax administrator.
Are you required to hold any special certificates, license, undergo any yearly training or specific education for that position?
Yes.
How long have you had your licenses?
My primary license is a registered professional appraiser I've held for over 10 years. Other licenses of various lengths.
How long have you been employed as chief appraiser?
7 years.
Without going into all the responsibilities and duties that you hold as a chief appraiser of Van Zandt County, is it your responsibility to review ownership of the properties in order to identify who is the proper owner for taxes to be assessed?
Yes.
And are you authorized to make such determinations
Yes.
through the property tax code?
Yes.
When making these decisions, what information do you rely on?
We rely on deed documents that are filed with the county clerk's office,
And is that the accepted and usual standard and practice among chief appraisers?
to my knowledge. Yes.
Is it also your duty and responsibility to evaluate, grant, or deny any tax exemptions in Van Zandt County?
Yes, it is.
And when I say your duty, you don't always necessarily look at every single one. You have a staff that you delegated your responsibility and authority to, correct?
Correct.
However, in this case, not only has others in your office made that determination, but you've had a hands-on approach in this case also.
Yes, I reviewed that for the initial decision was made.
And as the chief appraiser, you're authorized to make these decisions for both ownership and the status of exemptions for all of the taxing entities in Van Zandt.
As the chief appraiser for appraisal functions, yes.
Does your office also handle the tax collections and the delinquent tax collections?
Yes, for 21 of the 24 entities in Van Zandt County.
All right, let's talk about the ownership issue first. Did you make a determination about the ownership in this case? For the record, that is property ID or PID number 243.
Yes.
How would you just summarize that you made this determination?
I primarily reviewed the deed filings with the county clerks that were on record. And as we saw those filed, if they were not conflicting any prior document, we transferred ownership.
The deeds that we're talking about in this, Judge, if I may, are what has been marked as Exhibit E and F. And then later you were presented with the one that has been marked as J, that Mr. Donaldson stipulated to earlier, that's marked as Exhibit D in his brief. Are those the deeds that you used to make the determination?
Yes, they are.
All right, I know that's confusing referring to it as two. I'm gonna hand you a piece of paper that has been marked as Exhibit H. Do you know what this is?
Yes, sir.
What is it?
It is a property owner notice of protest.
And is that the title on the document?
It is.
This piece of paper was prepared by the defendant, Mr. Donaldson, correct?
To the best of my knowledge, yes.
And was it delivered to your office by Mr. Donaldson?
I believe so. It was not personally delivered to me, but that is my understanding.
And just to make sure, to your knowledge, the reason we're basing these assumptions on there is there's a signature on the back of the form paper that is purported to be Mr. Donaldson's signature, correct?
Correct.
Is it your practice to keep these forms in your records for future use?
Yes, it is.
And are you, as chief appraiser, also the custodian of the business records for Van Zandt County or Central Appraisal District?
Yes, I am.
Is that an exact duplicate of the paper submitted by Mr. Donaldson?
It appears to be.
Were there attachments included with the document that Mr. Donaldson provided?
Yes.
Are those the exact duplicate of the attachments provided by Mr. Donaldson?
Yes.
Your Honor, we would introduce what has been previously marked as Exhibit H, which is a property owner's notice of protest and the attachments thereon. It is signed by Mr. Donaldson, and it does survive any hearsay objection under Rule 803 subsection 15, as it is a document that affects interest in property. And it is relevant to the hearing.
Mr. Donaldson, any objection to plaintiff's Exhibit H? Maybe, Mr. Graham, you can show that in the camera up there, right there in front of you. It's this little one here.
No, Your Honor, I know, I'm familiar with it.
Okay, there being no objection, plaintiff's Exhibit H is admitted into evidence.
Mr. Donaldson purported to have a deed at that time, correct?
Correct.
And that's included in Exhibit H.
Correct.
How was this presented to you, Mr. Hyde? Sorry.
I believe in my conversation with Mr. Donaldson, this was a photograph of the warranty deed.
And did you know if it was a complete warranty deed?
I did not. This was the extent of what I got to view was just this photograph, and I've never received notice that it was filed with the county clerk's office.
Is it safe to say that a picture of a deed that has not been filed, that is not presented before you at the time, is outside the standard practice that chief appraisers would rely on to make ownership determinations?
Yes.
And the deed was not filed at that time, correct?
To my knowledge, no.
At the time that he presented it to you, was there a conflicting deed?
In my opinion, yes.
And that is the deed from Chapman House to Arise, correct?
Correct.
All right. In your opinion, as chief appraiser, who is the owner of the subject property?
Current ownership is in Arise Church of Canton.
Let's talk about exemptions. Did you make a determination about any exemptions on this property?
Yes.
Would you summarize that decision briefly?
Just to clarify, is this the exemption for Arise or for New Beginnings?
For new beginnings.
New Beginnings. We did originally, I believe it was in 2017, after the purchase of the property, they did submit an exemption form, and it was approved based on their proposed use of the property.
And how about the exemption for Arise?
Arise Church of Canton filed an exemption form in late 2020. We denied that based on no use of the property, and they had not done any site preparation or construction to bring it to the approved use at that time. So we did deny it for 2020.
Was there any appeals made from those denials?
No, there was not.
Are you familiar with the remedies in Chapter 41 of the Texas Property Tax Code?
Yes.
Did Mr. Donaldson or Ms. Harbor, either one, exhaust their remedies under Chapter 41?
No, sir.
Okay. You mentioned that your office and you collect delinquent taxes, is that correct?
That is correct.
And are you familiar with suits that are filed on your behalf and on behalf of the entities?
I am.
Our office provides a list or otherwise lets you know about every subject property, correct?
Correct.
And is the property identified as PID 243 RR 000, however many zeros, 243, the subject property in this suit?
Yes.
When you identify properties for taxpayers for the purpose of assessment, do you rely on a situs or mailing address?
No, we do not.
Do you rely on a legal address?
We do. Legal description
And where do you get the legal description from?
from the instrument of conveyance or the deed.
This particular piece of property has actually been known by 3 or 4 different mailing addresses, correct?
Correct.
901, 707, 673 West College Street.
Yes. I believe so.
Just for the sake of the record, we call it 901 College Street. That's all the property. All right. However, you don't rely on the address to make any decisions.
No, I think for simplification purposes, that's why we assigned an account number. So we don't have to describe the deed every time we're looking at property.
Your Honor, at this time, we would pass the witness.
Mr. Donaldson, any questions of Mr. Hyde?
Mr. Hyde, this exhibit that you have reviewed, the protest, you stated that this was the first time you became aware of the deed. Is that correct?
No, sir. I believe we had a discussion about it.
Okay. In 2019, was your office provided with a copy of the deed and a decoration of a homestead decoration?
I believe we were at the time that you submitted the notice. I don't know the exact date. I believe it was towards the end, late 2019.
And did you tell me that an unrecorded deed could not be accepted by your office, that it wasn't valid or something to that effect?
I'm sorry, I just may have misspoken. I believe, I said 2019, I believe this protest was submitted to us in late 2020. That's what I understood. I don't have a stamp copy. We typically stamp these in our office with the receive date, and this one does not have one, so I'm not exactly sure the date it received, but I believe it's late 2020 because it was signed as of December 22nd, 2020, so it would have to be after that.
Okay, attached to that protest, there's 3 attachments, correct?
I've got 4 pages.
What is the first page? I'm sorry, is the first one that says, "My name is Barney Donaldson"?
Yes, sir.
What is the second page?
The second page is on the back of that is a cover letter dated June 14, 2019.
Okay, so you were given notice of the actual deed in 2019, correct?
To my knowledge, I never viewed this letter until we received this notice of protest. And to my knowledge, our office did not receive this letter until we received the notice of protest in late 2020.
Okay. The bottom line, is it your position that a deed is not valid if it's not recorded?
No, sir, I'm not disputing the validity of that, but we don't look at it as recorded because there can be a conflicting deed, especially when we were presented with one that was conflicting a prior deed that was recorded. But for tax assessment purposes, we rely solely on the items of instruments of conveyance with the county.
Okay. Final question is, how did you determine that the property properly transferred to New Beginnings when it was transferred by someone other than the Chapman House? How did you determine that that deed was valid, but all the other one wasn't?
appraisal district, are not policing deeds, but we typically look at that, and if we don't see a deed that was already previously recorded in conflict with that, we transfer ownership.
Okay. No further questions, Your Honor.
No questions, Your Honor. We would rest and ask to close.
All right, thank you, Mr. Hyde. You may step down.
May I call one witness?
Well, I believe that you had already rested your evidence, but you have any objection to him reopening?
Tentatively, I do not have a objection to reopening.
All right, go ahead, Mr. Donaldson.
Jamie, can you hear me?
Yes, I can.
Okay, just want to clarify a few things on the record. When New Beginnings and all of us were involved in the previous litigation, and we were required to leave the property, do you recall a break-in at the property?
I do.
You recall extensive damages and a lot of stuff stolen from the property?
The damages that I don't know, there was a couple of things stolen, but I'm not.
All right. Did I ask you to go through the office and look for the deeds, several deeds in that office?
You did.
Did you
I'm
find
gonna-
the deed?
I'm gonna object on this as hearsay outside of court, and I'm not exactly sure where this is going.
I'm going to establish a few things to show that he's in error, Your Honor. This is simply rebuttal to some of the things that he's admitted.
Well, I'm gonna object as to hearsay. I'm gonna grant the objection as to hearsay.
All right. May I ask?
You can continue asking questions.
He entered a stipulation where the property was transferred to from Chapman House to Rise Church. Ms. Harbor, at the time that the property was transferred, were you aware that the church had liens on the property?
There was from my understanding, there was an attorney fee lien at the time, but that's all that I was aware of, that I
Were you-
remember.
Were you aware that I had claim to one room in that property?
Well, I was told the same kind of what they're saying, that that was not valid once the transfer was made.
At the time of the transfer, did you say that y'all would take care of me when I got sick in that room?
I did.
So it was understood that I would be, once y'all got open, I would be returning.
Your Honor, I'm gonna object again as hearsay.
I'll overrule the objection. You can answer.
Oh, no, actually, I was not. I figured after all that had gone on that you were parting ways, as you said, you were going to leave. So I wasn't aware that that's what your intentions were still.
All right. No further questions.
Any additional evidence or witnesses? Mr.
Were you asking me, Your Honor?
No, I was asking Mr. Donaldson if he had any additional witnesses or evidence.
No, Your Honor, just, do you want me to go ahead and close?
Just a moment. I'm just gonna ask Ms. Harbor if I didn't know if Ms. Harbor had an interest in today's hearing with regards to your request to partition your room and the taxes, and the tax levy against it. So, Ms. Harbor, were you wanting to present any evidence or witnesses today with regards to Mr. Donaldson's mission to partition?
No, sir. I did
Okay.
have a request to Mr. Height, I believe, to ask a question. I didn't know if I was able to do so.
Yes, if you want us to bring Mr. Hyde back and you want to ask him a question, you can do so. Would you like to?
Yes, sir.
Okay, Mr. Hyde, if you'll just reapproach. And sir, you understand you're still under oath?
Yes, sir.
All right, And I'm sorry, Ms. Harbor, I didn't ask you earlier if you had any questions for Mr. Hyde, so my apologies. Go ahead, Ms. Harbor.
Mr. Hyde, I was hearing what you were saying earlier and then regards the exemption, and I understand after given so many days, you file with the ARB to dispute the being non-exempt. But I was wondering if you were aware of the Texas tax code for property exemptions, Title I, 11.20, subsection A6.
I don't have that memorized, so I would say no off the top of my head.
Your Honor, can I read what it states?
You may.
Title I of the Texas Tax Code for property, real property owned by religious organization, provided the land is owned by a religious organization for the purposes of exemption of a place of regular worship or construction of a new place of regular worship may be exempt for no more than 3 years and then be reassessed by the chief appraiser. I understand that the response that was given in the letter for denial was the fact that we had the court order in place. I understand what the court order states, but the Texas tax code law itself, I could be inside painting the buildings, the walls and things like that. And we have been inquiring of and saving up monies to do further improvements. From the tax code law, there's not stating that we have to be currently, we have 3 years to be under construction. If it doesn't meet the requirements, then we can be denied exemption, is what I was getting to. And the exact letter, what your office sent me denying exemption, was because we had the court order in place and we're not under construction in 2020. And I state that was hearsay.
Your Honor, just for clarity of the record, can we break this up into individual questions? This is a compound question would be the official objection, but I can't imagine an easy way for this to be answered for Mr. Hyde without dissecting everything. Is it possible to break that up into multiple questions?
So Ms. Harbor, after you've read the portion of the tax code, can you ask your question of Mr. Hyde again?
My question is, your office did paper, the exemption was denied because of the standing court order. Is that correct?
No, it was not denied for the court order specifically. I think it was for multiple reasons. And part of that stemmed from the prohibitions in the court order. But I think the primary reason it was denied was there was no ongoing religious use, qualifying religious use because the court order prohibited occupancy of the building. But I think a separate issue would have been either the site preparation or construction to bring it up to standard where it could be used. And for the 2020 year, we were not with evidence showing either site preparation or use. Although that doesn't preclude a future year that began with potential for later.
Right. Well, your order, I had sent over the arguing statements of those things because the order does not prohibit occupancy. It prohibits occupancy unless things are taken care of. There's permission to go onto the property to take care and remedy those things. And so that was, the order was sent over, and then also the Texas tax code regarding those things. But I guess my question is again, just like the we were exempt by the state. Our papers are valid. The state has already given us exemption. So therefore, according to this Texas tax code, you still have 3 years to grant us that as well. And what your letter stated was that we had no construction in 2020.
Your Honor, the Texas property tax code requires defendants to exhaust all remedies under chapter 41, which is what Ms. Harbor was mentioning a few minutes ago. Once she's denied, she has to, within a certain amount of time, appeal to the ARB, or the Appraisal Review Board. This was not done. And she hasn't laid the foundation to be able to ask these sort of questions. I'm going to object to the questions as not being allowed in district court without the chapter 41 remedies having been exhausted. So for this line of questionings about trying to litigate an exemption, or specifically, Ms. Harbor, just so you know, specifically for 2020, which is where my concern lies, I object to this line of questioning.
I understand.
Do you have any response as to why I should allow?
I'm sorry, can you repeat that?
Do you have a response to his legal objection as to why I should allow the questioning?
No, Your Honor.
Okay.
Your Honor, just
Well, then let me rule. So the court's, go ahead.
Your Honor, just for Ms. Harbor's knowledge and edification, a 2020 denial doesn't stop you from reapplying in 2021, Ms. Harbor. Just so you know, if you want to apply again, a denial this year doesn't stop you from the next year or the following year. Not relevant to the case at the moment. I just wanted to make sure you did understand that, all right?
Right, is there a way I can talk with y'all outside of this court?
Yes, ma'am. I'll give you my email address when we're not on public. I'll
Okay.
be more than happy to chat with you.
Thank you.
All right, Ms. Harbor, any more questions of Mr. Hyde?
No, sir.
All right, Mr. Hyde, you can step down again.
Could I add one thing? Just, I would also invite you to contact me. I would be happy to help you. Mr. Brand indicated with your attention as well.
Yes, sir. Thank you.
Thank you, Mr. Hyde. All right, Ms. Harbor, I'm just gonna, we get most of that background noise from you, so I'm just gonna mute you and then bring you back on in a second. All right, if there's nothing further, then we're gonna let Mr. Donaldson make his request for relief. Go ahead, Mr. Donaldson.
Okay, Your Honor. On record is a copy of a deed. Oh, damn it. Now I'm hearing echo real loud. On record is a copy of the church's deed confirming that it transferred a room in that property to me. This is filed of record. The original deed was lost. All that's left is a photograph, but the one that's been recorded confirms that this is a valid deed. I paid $75,000 for that deed. I don't believe that anyone has standing to challenge that deed except the current. I believe Ms. Harbor, if she wished, she could have standing, but other than that, this is a contract. Privity issues are involved. Bottom line is, I'm out of $75,000 that was tendered for that piece of paper. And there is record of the payment being made. I think that under the tax code, the correction deed, along with the photograph of my original deed, is sufficient to establish that I have title to that one room in that property.
Are you referencing your exhibit C?
I'm sorry, go ahead.
You said there was a photograph of a deed. Is that what you're referencing?
Get back here again.
Has that been admitted in evidence?
Exhibit D was admitted, which references that exhibit C.
Okay,
It's
yes.
an attachment on Exhibit H.
Okay, I see it now. Okay, thank you.
There has been, I was the grantee in that I have not signed away any of my rights, individual rights to that one room. And all I'm asking is, I'm not trying to avoid payment of taxes. I'm simply asking that my share of the taxes be calculated so that I can pay them.
Okay,
This is not an uncommon situation. There's a lot of times when taxes are become an issue, there's an unrecorded deed comes up. And in most cases, the courts do partition because the law is well settled that whether a deed is recorded or not, it is an effective conveyance. And this, you may recall, this came up in the previous case involving the city of Canton attempting to enforce the municipal ordinances on them. They sued not only New Beginnings Fellowship Church, but they sued me separately as an individual property owner.
all right, thank you, Mr. Donaldson. Ms. Harbor, do you want to be heard at this time as well?
You got to turn your microphone on, Jamie.
Yeah. I don't have any further at this time.
Okay, thank you, Ms. Harbor. Mr. Brain, go ahead.
Your Honor, we've got several things wrong with this. First of all, I'm going to go ahead and argue res judicata in this situation. The certified copy, which was also filed of record in the county clerk, since it does affect land, clearly states on page 4 of it, if you have it, that Arise Church is the owner. It considered Mr. Donaldson's claim. The court looked into it. Everything was agreed and stipulated to. At the end of it, Arise Church is the owner in fee simple. This entire issue has been litigated. Mr. Donaldson does not get to, under the guise of a delinquent tax, come back and relitigate this, what is essentially a chain of deed. He has an unfiled document that was considered and is an exhibit in the Exhibit D, which was heard in this court and has a final order. So to begin with, res judicata applies. Mr. Donaldson is barred from raising these arguments.
I'm going to object to that. Simply put, if Your Honor will recall, I was non-suited from that case. I was not a party to that case. The city of Canton, they all non-suited me. And my appeal on the same issue was dismissed because the issues were moot. They non-suited me. Res judicata would only bar it if I was a party to the final judgment.
Property itself is a subject to the, is attached and is under the jurisdiction of the court at that time. Res judicata would apply. Also, Your Honor, if I may, the unfiled deed argument is an invalid point here because we live in a race notice state. An unfiled deed can have validity in a hearing, in any situation to mute title if someone else has not beaten the unfiled deed to the courthouse. Clearly here, as again, I re-urge res judicata, this was all heard in the court. Evidence was submitted before, evidence is submitted here that New Beginnings conveyed their interest to Chapman House in the whole, in fee simple, to Chapman House. Chapman House then conveyed their interest in fee simple, in the whole, again, both times without any reservation, without any encumbrances by New Beginnings. They were filed of record. Ms. Harbor received this, and as she stated a little while ago, it's her understanding that Mr. Donaldson has no interest in this. Again, as stated in 19, or in the previous suit, 185, Ms. Donaldson is what is called a subsequent purchaser for value. I don't know the terms. I don't know if Ms. Harbor gave $10 or $10 million, but she is a purchaser for value, in which she is allowed to rely on the deed from Chapman House to her. Mr. Donaldson coming in 2 years after which, with this miraculously appearing deed that conveys interest to him, is completely improper. It's already not only passed from New Beginnings, but from Chapman to Arise. There is no interest that he's allowed to reserve. She is a purchaser for value. We must rely on the deeds. As to standing, it is clearly in the chief appraiser's, Mr. Hyde's, discretion under his responsibility and duty to decide whether or not to partition, whether or not to divide it up. It solely rests on his shoulders and those of his staff to properly assess the persons or entities who have, or who to assess taxes to. Mr. Hyde did such in his professional capacity. You heard him say here that what was presented to him had conflicting needs, did not meet the standard. Mr. Hyde's not saying because it wasn't filed, we can't assess it. He said that in the entirety of the view, the fact that there was conflicting deeds, the fact that there was a final order, again, back to the res judicata, that there was a final order that named Arise as the sole owner, which is very clearly stated on page 4. Your Honor, your copy should be highlighted in there, where the entire chain of title is discussed on page 4 of that order. Because of those facts, New Beginning has no interest to be able to convey to Mr. Donaldson.
I'm going to object to that. Simply put, at the time that final order was entered, I had been non-suited. I wasn't a party to that order. That order is not binding upon me. It's that simple. There is a deed that was entered. And Your Honor, I'm not trying to be difficult here, but you'll recall all the litigation of the previous case.
I do.
Our property was broken into. Lots of stuff were taken. Somebody thought that these deeds, there's more than just my deed. There was a deed to like 6 or 7 other people. These things just mysteriously disappeared out of our property. Somebody thought that they were getting something. That's the only reason why this thing wasn't filed when it was recorded. I mean, when it was made. Go ahead, Jamie.
May I, so in the
Well,
documents
hang
here.
on, hang on, Ms. Harbor, Ms. Harbor. So Mr. Brand,
Sorry,
closing argument. So there's an objection by Mr. Donaldson. I'm going to overrule the objection, allow Mr. Brand to continue, and then I will allow you, Mr. Donaldson, to have your final argument, okay?
Your Honor, finally, Mr. Donaldson's argument is self-defeating. As you notice, we've been kind of all over the place here. I asked him specifically, are you adopting the argument that was in your answer? In that one, New Beginnings never actually had ownership. He talked about it. It's all over the place. I'm not sure which one of the arguments we're wanting to rely on here. Ultimately, regardless of which one of the alternatives we pick, whether it's res judicata, whether we rely on the record notice statute that this state relies on, or, Your Honor, the subsequent purchaser, any of those defeats this entire argument. Our standing is based on that this is completely within the discretion of Mr. Hyde, in which he was denied. Mr. Donaldson was denied by Mr. Hyde to partition it. And Your Honor, we'd ask that this motion for partition be denied.
Thank you, Mr. Brand. Go ahead, Mr. Donaldson.
I just have one final question for Jamie Harbor. May I ask her? I simply want to know if they object to the partition. She hasn't stated whether she objects to it or not.
Well, you should have called her as a witness at that time. So I'm going to allow her to be heard, and if she wants to respond to that, she can. But the time for question and answer is already passed. I've given everybody that opportunity. Okay, so do you have any other closing argument remarks?
No, Your Honor. I think I've said everything needed to be said.
Thank you, Ms. Dawson. Ms. Harbor? You'll need to.
Amy, your microphone's off again.
Am I answering Mr. Donaldson or?
No, Mr. Donaldson has had the opportunity to question you. He didn't. So now it's just your closing statement. And if you want to reference something in there, you can, but we're not in a question and answer session at this time.
Okay, I did find in the documents that were filed that we were served as a Rise Church of Canton on May 20th of 2020. This was served to us, and Exhibit 1 of that suit, which is the 1900185. Exhibit 1 actually does have a copy of that deed being filed and recorded, public record 4/3 of 2019 at 9:15 a.m.
Anything further, Ms. Harbor?
I did have another question about the or about the deed thing, but I don't remember at this time. So.
Okay, well, we're through with questions. If you want to talk to Mr. Brand, Mr. Hyde outside of court, you may do so, but
Yes.
you've been brought in as a party, and Mr. Donaldson has filed a motion to partition the tax levy on what he's claiming to be his separate property, his own property in room D7. So if you don't have anything further, then what the court's going to take this under advisement. I'm going to review all of the exhibits and the argument of counsel and the ruling to the parties. What I would ask you to do, Mr. Brand, and you as well, Mr. Donaldson, is to file your proposed order with the court.
But Your Honor, before we adjourn for the day, I've got a couple of motions that I would like to present to the court.
With regards to Mr. Donaldson's,
To Mr. Donaldson and just in general in the case, I would ask that the court ask Mr. Donaldson or order Mr. Donaldson not to have contact with any of the clients in this case. He has been harassing several of my clients. They are uneasy with talking to them. They are represented by an attorney. All communication should go through me.
all right, the court's going to order that all communications occur occurring between the parties be conducted through the counsel if that party is represented.
Your Honor, I would also add what is ultimately going to be an oral attendance, and we will file one with the county clerk this week. But I would like the court to, for the court to emphasize that this property is under the jurisdiction of the court and prohibit any of the defendants from conveying any rights, interest, or privileges of the subject property, including encumbering it with any contracts on the property itself until the underlying delinquent tax case is settled.
Is there legal authority for me to do that?
Yes, sir. It's the jurisdiction of the court. Therefore, the property, as with any other estate or as with any other piece of property in the court, cannot be diminished until we resolve this.
Okay, then the court will grant that motion.
Finally, Your Honor, should the court grant, or should the court deny this motion for partition that there be a motion in limine that if we get to trial on this, if we're not able to work out some sort of a payment plan with Ms. Harbor and Christ Church, that we should wind up at a jury trial as requested by the defendant. Motion in limine that we not bring up the issues of either exemptions or denials in general, because they have not exhausted and time is preventing, they're not allowed now, since they did not exhaust their chapter 31 and with the partition order.
What I'm going to do is I'm going to order that the motion in limine be reduced to writing and filed with the clerk, and then we would take that up at the pretrial setting if the case is scheduled for trial.
Correct.
So I'm not granting the motion in limine at this time.
Yes, Your Honor. That's all I have.
All right, so,
John, may I
yes,
ask-
sir.
I'm not clear on who he's asking for me not to communicate with, his clients, or who is he talking about?
The
Sure.
city of Canton, the Canton ISD School Board, the Van Zandt County, any of the employees at the Van Zandt County, any employees at the Van Zandt Central Appraisal District, or any other taxing entity in Van Zandt County. Mr. Donaldson is not an owner of property in Van Zandt. He does not reside here. If he has an issue other than this piece of property, if he has an issue other than this lawsuit, I'm not asking for him, prohibited from contacting them about that. Anything that has to do with this lawsuit, this piece of property needs to go through me.
It appears, I understand what he's asking now. I was scheduled to speak before the City of Canton School Board about this issue. Or is he asking that I not appear before a board and discuss it?
Yes,
Because that's a public forum. When I contacted them, they were not even aware of this lawsuit.
that's not true.
I have a recording. Never mind.
So the court has already ordered that
Okay,
any communication regarding this litigation on this property
okay.
between the parties be communicated to counsel of record for the party. And Mr. Brand has stated who his clients are, and so the court's going to order that.
All right, I understand.
Okay, all right, so we'll, I want you to file your proposed orders with the court, and the court will take this under advisement until I've had enough time to review the evidence and issue a written.
Thank you, Judge.
Thank you.
Thank you, Mr. Donaldson. Thank you, Ms. Harper. We'll be adjourned in this case.
Your Honor, can I get the information from Mr. Brand before we leave?
Yes, give me just one moment.
Okay.
Your Honor, our office